Still on Bonku.
Still on Bonku, can I divert to some of the questions that were asked this morning, just to try and deal with those? I've got quite a lot to still get through before close of play today. But it may be convenient to pick up at least some of those issues. My lady may well have been told and be aware that the anonymity order is not, I'm told, being pursued by my learned friend. And so that's gone away, as it were. My lady asked about, I think, a question to do with the population at around the time independent Republic of Cyprus was created and whether the sovereign bases existed and so on. I think the best evidence that one has in relation to that, which the punchline of which perhaps is to emphasize that they were intended not to have civilian populations, the SBAs, but that the civilian populations expanded during the Troubles in the early 1970s in particular. The best evidence as far as that is concerned, if I can just give you a reference without going to it, is in the witness statement of Lisa Young in Appendix Part 2C, tab 180, MS, for relevant purposes, 2530 to 2531, and the relevant paragraphs explaining that are at paragraph 6 and 7 of that statement. Lord Reid asked why are we in international legal territory, effectively. Fair question. And I'm told that the reason for that is essentially that it's been accepted throughout these proceedings that paragraph 11 of my learned friend's case is correct, as far as that is concerned.
The 2002 Act. 2002
Act, effectively. My Lord Wilson asked a 93 Act. Whatever act is referred to in paragraph 11. Lord Wilson referred to the fact that one of the document that was sent to these claimants said, we are determining that you're a refugee under the Refugee Convention, and the point was, has it not therefore been conceded and accepted that the Refugee Convention applies? As a result of that, I think the document my Lord had in mind, if I have the right one, is at Appendix 2A1, tab 76, page 1346, which does indeed say what my Lord said it said.
I actually was taking it from the Statement of Facts, and
paragraph
25, which talks about orders rather than a letter, Mr. Eady. Yeah. Orders made by the Chief Control Officer.
I think it's the document I've given.
Is it? Thank you.
I think it is, but that's where you get it.
So what's the legal effect of that?
Can you give me the page reference?
Yes, I'm sorry. Appendix 2A1, tab 76, page 1346. Yeah, it's an order for release from detention, I think.
Yes.
But I think the passage that my Lord entirely fairly had in mind was the second paragraph of that document.
And the Statement of Facts and Issues indicates that each of these claimants got a revocation of order like this. So this is an example.
It's an example, my Lord, yes, I think that's right.
So what's the legal effect of that?
My Lord, we respectfully submit that the legal effect is not it can't alter the position as to whether or not, as a matter of law, the Refugee Convention applies or doesn't apply in the SBAs. Its only potential legal effect could have been, or might have been, to tee up an argument that there was a legitimate expectation of some kind created on which the claimants could then rely. But no such argument is run or has been run, no doubt because of all the various conditions that attach to the creation of a legitimate expectation. So it isn't asserted to have that legal effect.
The legal effect is what it says, the revocation of the order under Section 11.
And limited to that. But the question I think that's being posed is, has this in some way created a legal consequence?
Yes, but there's no res judicata applying to these things.
No, there isn't.
At most it could be as an estoppel of some sort, but as you say, that's not being
and it isn't run on that basis. And I think in fairness to the although it's cast in perhaps unsuitably absolute terms, as it were, but if one wants an idea of what people were thinking round about that time, if you go back in the same volume to tab 70, MS page 1332, I think this is the closest we've come to what people were actually thinking at the time. And as I say, it may not have found reflection in the tolerably unqualified language of the document we've just been looking at. But if you look at paragraph 6 of that document, so in effect, they're, as it were, struggling with refugees or potential refugees arriving on their shores. There's a bit of spirit of the convention within paragraph 6 as well, as you see, and they're trying to find some practical way of dealing with the issue. So as I say, although, of course, the document at 1346 says what it does, that at least provides some context as to what people were actually thinking. But that's the answer to that, or the best answer we're able to give in relation to that.
I mean, I read somewhere, I think in the Court of Appeal, that you did agree that you were obliged to honour the spirit of the convention.
Mildly, yes.
So, I mean, my question could slightly be redirected to what are we doing about issue 1 in circumstances where you agree that as a matter of spirit, the convention has got to be applied?
Well, I think the significance, if any, my lord, is an entirely fair question. The significance, I think, is, if any, is whether one has whatever leeway may be inherent in the concept of spirit.
I see.
Is that a legal issue?
Well, it isn't a direct legal issue in these proceedings, but the parties have broken them down in that way.
Well, how do you keep faith with the spirit of the convention if you don't apply it?
Well,
closely aligned to it.
Closely aligned, but not necessarily following all of it. But anyway, the short answer may be that it's too interesting a legal issue to leave on one side. But can I move briefly to a question that was raised by, I think, Lord Carnworth, about and I think Lady Hale as well, about the territories signing up and when they signed up to the various Refugee Convention and indeed the protocol later in 1967-68. And do you remember, if you have two documents open, if you would, one is the document I took you to before, which is in Core Volume 3 at tab 33, page 1068. I'm not going to go back over all the documents, but you recall, if one just has that one open, and you also have open, if you would, if you still have Appendix 2A1 open, in that file, if you go, please, to tab 64 and page 1283. So you'll recall from 1068 in Core Volume 3, bottom of the page, right-hand column, that I referred you to the United Kingdom signing up by excluding, as it were, certain territories, Jersey, Southern Rhodesia and Swaziland in A, and positively extending the provisions of the protocol to St. Lucia and Montserrat.
Yes. I see them on the list here.
You see them on the list on 1283? Yes. Well, my lady, then you're probably well ahead in terms of the answer. But the position appears, therefore, to be that the explanation for the specific extension to St. Lucia and Montserrat, going to page 1283, is that they signed up, it appears, to the entire structure, as it were, 51 and 67, at the same time on the 4th of September 1968. And that's why there's a specific extension, as one sees, at 1069. And in relation to the ones that are excluded at 1068, that's Jersey, Southern Rhodesia and Swaziland, the need for that was because out of the group of territories that are in relation to whom declarations and or notifications had already been given, following consultation, no doubt, about the protocol, they were the ones who said, we don't want it to apply to us, and so this is a disapplication of the deeming provision. Does that convoluted explanation make sense?
Well, it certainly answers my question in the way that I thought it should be answered.
Right. Well, I never know whether it's a good thing or a bad thing, but it looks from the nod at Mr. Hussain as it might be a bad thing, but never mind. But that is the factual explanation anyway. And you see that by then Cyprus is, to come back to that, Cyprus is on the list, but only on the list as having signed up at page 1283, or having had a notification made on the 25th of October 1956. So the question is moot, as it were, so far as they're concerned. That is that. And then back, if we may, to Bonku. You've read paragraph 64 and 65 of Bonku, and I've made my submissions about the two steps in the reasoning. Step one, declaration applies to a political entity, not to the land that is from time to time comprised in its territory. Step two, thus, if a new political entity is created, the declaration ceases to apply and lapses. And of course, you will recall that whether you proceed on the assumption, as it were, that Lord Hoffmann thinks that the Biot was created by excision from the colony of Mauritius to create a new colony, or whether you take what appears as the true factual position, which is that the Biot as a colony was created out of two earlier colonies, in other words, Mauritius and the Seychelles, might be thought matters not for present purposes, because in relation to both, and this is an echo into Lord Wilson's question about legal entity, political entity, in relation to both, or either, the territory in question, i.e. the territory of Biot, remained at all times colonial. It remained at all times under the sovereign authority of the United Kingdom, and it remained a colony throughout. It was just different colonies being created. And so the reasoning of Lord Hoffmann and of the majority of the House applies in a situation in which the new entity continues to be under the sovereign authority of the United Kingdom, and indeed continues to be a colony. It doesn't make any difference whether it's created out of two bits of an earlier colony or one bit of an earlier colony, or excised from the other. It remains for present purposes under that. To come directly to my Lord Wilson's question, the legal entity versus political entity, how much one reads into the change of words as between the submission made on behalf of the Secretary of State and Lord Hoffmann's judgment is a philosophical question which I'm unable to answer, but there appears to have been a deliberate choice by Lord Hoffmann to cast it on the basis of a political entity, and it might be thought that that's the more natural inference, is that if the submission that was made was restricted to legal entity. But my respectful submission is that, fairly read, and if reported accurately in the law report, and there's no reason to suppose otherwise, the submission isn't necessarily restricted to pure legal entity as a submission. One sees from 2954, it appears in two ways which I suspect were not intended to be hermetically sealed. Between G and H is the first way it's put, which is focusing on simply on Biot being created, irrespective of whether there's a change of legal entity or political entity or something else.
If the test was legal entity, would you be able to argue that the legal entity of the bases was different from before 1960?
My lord, I would, and the reason I would is because my point of comparison is with the colony of Cyprus as an entity, a legal entity that existed at that time. And when the notification was given in 1956, the colony of Cyprus comprised the entirety of the area.
Well, that's a geographical point, not a legal point.
Well, it's a geographical and a political and a legal point.
I'm asking about the legal side.
The legal side, in my submission, my submission is that the colony of Cyprus as used in 1956 is different from the SBAs, even though they may have become, as a matter of domestic law, or stayed as overseas territories.
Was the word colony used in the 1956 declaration? I thought it was just Cyprus.
It was Cyprus.
So, I mean,
But the only...
simply by pointing out that Cyprus was a colony, does that actually get you to the point you're arguing?
My Lord, that was... I respectfully submit that if one looked at the 1956 declaration and asked the question, what is being referred to by the reference to the territory of Cyprus, it was to that legal entity, with all the structures that applied at that stage, with all the geography that applied at that stage, but as a matter of law, the colony
in international law, presumably, notice is taken of the treaty restrictions, and no doubt also, as a matter of good faith, the treaty undertakings of intention, which, I suppose one could argue, fundamentally change the character of this entity.
Well, it changes the character of...
Now, like an
either or both
offshore
of them.
fortress rather than it's no longer a colony, and presumably one aim in 1960 was to avoid it being regarded as a colony, or it would have been subject to the decolonialization principle.
And we saw that from the treaty, but it changes both the nature of the SBAs and, plainly, the nature of the ROC. So that's why I keep going back to the true point of comparison being with the legal entity, and indeed the practical and political entity that was the colony of Cyprus, which in my submission is what is being referred to in the 1956 declaration, as compared to either or both of the ROC and the SBAs.
Can anyone think of an analogy? I mean, has this sort of thing been done before? Obviously, people created all sorts of odd rights in international law, including rights to have courts in other people's capitals and so on. But this is a particular entity. Is there any analogy for it ever? I suppose Gibraltar has a flawed sovereignty in the sense that we can't transfer it. It goes back to Spain, I think. So if we try to make it independent or transfer it.
But so the analogy you mean is the analogy where the new territory, to use that word, is subject to international legal constraints.
Yes.
Operating with the
yes,
other
I
country.
mean,
I suspect that Gibraltar probably is the closest on that basis.
Or supposing if we let China have the new territories back but kept Hong Kong, therefore
Yes,
be
but-
separating Hong Kong into the two. It didn't happen, but it would be an analogy.
Well, one would have to examine the legal setup as far as
I
that.
mean, isn't the real question whether we can find any intention in 1960 to abrogate the obligations of the United Kingdom insofar as it had taken on obligations in respect of this particular bit of Cyprus? I mean, clearly, as far as the new state of Cyprus was concerned, that was a matter for it. But as far as the parts which we retained control of, it'd be a bit odd to find us having abrogated what we'd undertaken under the Refugee Convention without it even having been stated anywhere.
Well, the question really is what assumption one draws from the fundamental constitutional, legal, practical changes
my
in
assumption would
1960.
be that the United Kingdom would want to keep the obligations it had undertaken for territories in respect of the convention.
Well, my lord,
Not
that
split off a little bit by, the presumption, the absence of any specific provision, I'd have thought, was the continuity.
well, I'm not sure I'd necessarily accept that as
But I assume we don't.
as the right analysis, but simply because of all the reasons that I went through earlier on, political, legal, social, practical, as to why when you create a new entity or set of new entities from an old, the serious questions arise as to whether you are indeed to assume that the United Kingdom, in our example, did indeed intend the full-blown refugee convention to apply to military bases there. And that's why we respectfully submit. This is the very issue with which the House grappled in Bonku, which is what is the appropriate test for dealing with that assumption? Is it simply an assumption that it should all carry on? Because if that's the assumption, it applied a fortiori in Bonku. In Bonku, the thing remained a territory. The Biot remained a territory. It used to be part of Mauritius and a bit of the Seychelles, which were both colonies. It became a separate colony, but it was still nevertheless a colony. And
Mr. Eadie, we've been asking you an awful lot of questions and asking you to supply us with an awful lot more information. Very conscious of the fact that you're a long way through your time and you haven't yet got to issue 2,
really, I haven't.
which you might have guessed is the one that really interests us.
Right, well, I will speed up then, but I don't want issue 1 to be, as it were.
It's not going to be. It's
No.
not going to be. You've spent a great deal more than half your time on it.
Yeah. My lady, can I spin through some of the other points, therefore, on issue 1 and try and finish those quickly? But you had the submission on Bonku. We respectfully submit Bonku, as a matter of legal tests, is correct. Both its steps are correct. It properly reflects all of the points I made earlier on about territorial application clauses and how they work. It properly reflects the fact that there's a fundamental change of new issues arising, legal, political, social, practical, when the new world begins. And I do want to touch very briefly, if I may, on the denunciation provisions on which my learned friend places particular reliance, that is, the provisions in Article 44 of the Refugee Convention. And no such declaration is given by the United Kingdom under Article 44.3. And the question that arises, therefore, is what is the inference to be drawn from that? And my submission is that the natural inference is not that the assumption was, to use Lord Carnwath's word, or that the intention was for it simply to continue to apply, but that it had lapsed because of the changes it had made. That is, the earlier Article 40 declaration or notification had lapsed. If it had been given, just test it this way, suppose the withdrawal notification had been given, denunciation notification had been given, it would have been to withdraw the previous declaration that related to the colony of Cyprus, so confirming the negative proposition that the Refugee Convention didn't apply to the old colony of Cyprus. That's self-evident. And moreover, you will have seen from Article 44 that it contained a provision for 1 year's notice. So if you give that sort of notice under 44.3, it only takes effect a year out. Well, what would have happened then? Presumably, in theory, it might have been possible to give it a year in advance, as it were, of the signature of the treaty setting up the new arrangements, but there's no indication that that would have been a realistic thing. And then what? Would it have continued to apply as a declaration, even though you now have independent Republic of Cyprus, which has taken over a part of, the very significant part of, what was previously the colony of Cyprus? So far as the ROC is concerned, it cannot be that it's to be inferred that it was intended that the previous notification should continue to apply so as to bind the ROC until the UK said otherwise. The declaration hadn't been given in relation to them, and they are independent, so they can decide for themselves. And that is why I took you earlier on to Mr. Justice Foskett's Parrot 257 and the references to the clean slate principle. There may have been easier ways than re-acceding or starting from scratch to bind for the Republic to bind itself. But they started fundamentally with their own independent choice. And the consequence where there are 2 new political entities created out of the one old being the subject of the notification or declaration earlier, is not that the declaration stays in force for all the new and different entities, but in relation to the new one, it chooses for itself, because it's independent, And if that is so, it's hard to see how the old declaration could simply continue. And in any event, at a practical level, we know what constraints operated on the SBAs. And we haven't purported at any stage to give notification under Article 44 to any colony which has become independent. No such notification has ever been given, as far as I understand it. And of course, if that's right as a matter of inference from the non-application of Article 44, that doesn't deprive 44.3 of utility or practical effect. You can exercise that right to denounce when there is no change in the status of the territory. You just use it in that situation. Nor, we respectfully submit, does this sort of clause, the existence of this sort of clause in a treaty, obviate the need for and good sense of the House of Lords test in Bonku. That is for the same reason. 44.3 continues to have use. And when it isn't exercised, you don't just say, well, there we are. We all assume that the old declaration carries on for the colony of Cyprus, even though it ceased to exist, and even though we have a new independent state covering 99% of the territory with all its new political and social infrastructure. You have to ask a question. By what yardstick, by reference to what test, do you ascertain whether the old notification lapsed, or do you simply assume that it carried on? And my respectful submission is that the Lord Hoffman test in Bonku is a good way of identifying the correct answer to that question. Whether one approaches it as a matter of legal entity or political entity or analysis of all the circumstances to see the nature of the change. But whichever one you do, you judge it against the backdrop of what Article 40 and its declarations and notifications is trying to do. What is it actually doing? It's giving notification on behalf of a particular entity that no longer exists. But if you've got a new entity, therefore, that tells you that the correct analysis is lapse. State practice and MLAs and all of that, there's a very, very long section in Mr. Justice Foskett's judgment dealing with all of those. And we respectfully submit that he was right. My learned friend seeks to rely upon some of those international instruments and some of those practices to suggest that there is, in effect, state practice that the Refugee Convention continues. But none of the examples that he relies upon are sufficient for that purpose. Can I simply give you the headline answers, and I'll come back to it in reply if I need to. The pure answer to all this allegation that in the context of different treaties, different things were being done. So to take the MLAs, there's an office in the SBAs that will now receive your requests under the mutual legal assistance treaties, that sort of thing. The pure answer is, so what? The question in this case, or the questions in this case, are ones of treaty interpretation. But what does Article 40 mean? What did Cyprus refer to in the UK's 1956 notification, and so on? And we respectfully submit, therefore, that the first answer is it doesn't terribly matter. We know and fully accept that the Vienna Convention on the Law of the Treaties in 31.3 refers to the possibility that there is clear state practice so as to inform the interpretation of a treaty. But that requires one to be dealing with the practice of states generally, rather than a single state, or the views of a particular ministry within a single state, and that practice of states generally reveals a consensus as to what the correct interpretation actually is. And so we respectfully submit that Mr. Justice Foskett approached the matter by asking the right question at 246 of his judgment, and he was also right to conclude, as he did, in relation to the mutual legal assistance treaties, namely that there wasn't universal agreement amongst the various states, even in that context, to the effect that the change from the colony to the SBAs made no difference. C, as he correctly noted, the Lebanese view, which was that a new extension was indeed required. See his judgment, para 235. And moreover, the MLAs are obviously a different context from, say, the ECHR or the Refugee Convention, again, as he correctly noted at 248, second half of his judgment. And states don't always, as lots of authors have pointed out, and as Mr. Justice Foskett correctly noted at 237, they don't always act strictly logically in relation to these matters, as opposed to finding a pragmatically possible and sensible solution in the brave new world. The MLA one, it might be thought, is rather closer to that. So the MLAs don't take one anywhere. Then there is reference to a slightly different set of practices, where there is specific notification of denunciation on behalf of the SBAs themselves, but we respectfully submit that isn't remotely clear-cut as a state practice that can operate or bind in relation to the different context of Article 40 of the Refugee Convention or Article 44 of the Refugee Convention. This is the Convention on the Nationality of Married Women, dealt with in Mr. Justice Foskett's judgment at 241 to 244, correctly we submit. Then there are some other examples, perhaps, of treating territories as continuing to be bound after political shifting. That's a slightly different point. It's Jamaica and the Turks and Caicos. So far as that is concerned, we respectfully agree with and adopt Mr. Justice Foskett's judgment at 209 to 225, where he derived no real assistance in relation to that. And so the picture that emerges is not one of a consistent state practice at all, even in the contexts that are examined, of a series of different practices, if that's the right way of describing them, all being lumped together to make a point that doesn't flow from them, but on any view in contexts which are very, very different from ours, namely the Refugee Convention and its continued application in the SBAs. Perhaps the parallel of most use in relation to that, and the one that Mr. Justice Foskett found is most use in relation to that, is the ECHR, being a treaty of not quite the same kind, obviously, but a similar kind to the Refugee Convention. The ECHR itself, for your note, is at Authorities 8, tab 98, page 5508, and the relevant articles are 56 to 58, 5535, and they are broadly, they're not quite the same, but they are broadly similar to Articles 40 and 44 of the Refugee Convention. So what happened in relation to the ECHR after the changes in 1960? Well, the answer to that is that so far as the Republic of Cyprus is concerned, the newly created independent sovereign state, it had been extended to the colony, to Cyprus in 1953. That was a starting point. And one sees that, if you want it, from footnote 54 at Authorities 7, tab 71, page 5124. But after the changes in 1960, the newly created republic signed the ECHR in 1961 and then ratified it in 1962 rather than succeeding to it. And the letters to the Council of Europe in 1964, shortly afterwards, in relation to a series of territories that had become independent. So there'd been a hiatus, and someone wrote from the Council of Europe saying, lots of your colonies have now become independent, what's the position under the ECHR? So a letter was written in 1964 by the government. Might be worth very briefly turning that up. Core Volume 3, tab 34, page 1071. So this is in relation to the ECHR. 1071 is the page, and you see that in response to a question about, well, what about these colonies that have become independent or territories that have become independent? The answer is, see the last two lines of the lead-in paragraph, of the territories named in that declaration, that's the 1953 one, the following have since become independent. Cyprus, you see 16th of August 1960, is the first one referred to. And you see that the view of the government given to the Council of Europe at that stage on page 1072, the responsibilities which Her Majesty's government assumed under the Human Rights Convention on behalf of these countries lapsed on the dates indicated, revised list of, and so on. So that's the colony of Cyprus as it became the newly independent body. That was the position in relation to them. And so far as the SBAs are concerned, the sovereign base areas are concerned, see, if you would, A6, Authorities 6, tab 4785. Doesn't matter terribly what this document is, it's a Parliamentary Assembly document summarising various other things, but if you go to 4785, you will see the SBA, a title halfway down the page, the SBAs and the European Convention on Human Rights. And you see the title, Application of the ECHR to the SBAs, and from there you will see the terms of the declaration made only in March 2004, registered on the 1st of April 2004, by which a declaration was made by the government of the United Kingdom in relation to the SBAs that the ECHR should apply to them thenceforth. You'll see the declaration is made on behalf of that territory, but so in 2004 it applies. And it may be that you choose to note, I think in Quark Fishing, the House was concerned about why it was that Article 1 of Protocol 1 had not extended to the Falklands and the territories that were being dealt with there. And the answer to that appears to be, was likely to be in paragraph 11 of this document. But you also see from paragraph 12 that on the 5th of April, I think it was, 2004, there was specific local law made equivalent to the HRA. There was an ordinance, a human rights ordinance, and if you want that human rights ordinance, it's in Core Volume 3, tab 38, page 1117. So they create their equivalent of the HRA on the matter of days after this declaration is made. And of course, on the claimant's case, the UK's extension of the ECHR to the SBAs was completely otiose, because they say it already extended to the old colony. And so we respectfully agree that in relation to the human rights position, both internationally and nationally, the better view is that expressed by Mr. Justice Foskett at 249 to 250 of his judgment. So we submit that that's an interesting and important part of the piece, because everyone's looking for similar looking, it's not identical of course, similar looking treaties and how they're dealt with in relation to the newly created independent republic and in relation to the SBAs, that's an indication of it. That's all I want to say on issue 1. Issues 2 and 3, the applicability of and the nature of the various articles under the Refugee Convention, assuming that it applies either directly or in spirit, dealt with in our case at paras 38 to 63 and in our responsive document, which I hope you have but isn't in the electronic bundles, I think, paras 35 to 43. These issues were not addressed by the learned judge at first instance, because he held that the Refugee Convention doesn't apply in the SBAs, and it wasn't answered by the Court of Appeal, because the Refugee Convention, on their view, did apply, but there hadn't been consideration by the Secretary of State on that basis, so reconsideration was ordered on that basis. And as you know, in the light of the Court of Appeal ruling, there was then a new decision superseding the old, which is why I say that the whole thing's got a bit of an academic flavour. Superseding the old, a new decision was made on the 6th of July of this year, on which no court has yet ruled, and in which the Secretary of State maintained the position that there was no obligation to admit to the United Kingdom, and that's the bold question, under the Refugee Convention or its spirit. And I was going to deal first with the issues of principle and make submissions on them and then return to the correct procedural course. But you will appreciate that there are, on our submissions, some quite serious practical and procedural issues arising as a result of that new position. Not least because the new decision of July of this year supersedes the old, so there's no point in ruling on the old version. And also because even after that decision of July of this year, there has been a fresh intervention, if that's the right way of describing it, by the United Nations Commissioner for Refugees, and they've raised a series of questions in a letter in late October, as to whether or not there is indeed a durable solution of some kind on the island of Cyprus. And that is a letter to which the Secretary of State has not yet responded. I'm told that a provisional response is expected imminently. And we will, of course, send it to you and provide it to the other parties as and when that occurs. But it does raise a question about the extent to which there are truly issues that can sensibly be resolved, at least as to whether or not there is an obligation to admit, pending a resolution of those as yet unresolved issues. But it may be that the court feels it's appropriate and possible to opine on some of the issues of principle that appear to divide the parties. Article 26, if I may, which is free movement and choice of residence. You have relevant substantive provisions of the Refugee Convention, as you know, behind tab 24 in Core Volume 3. It is said to confer a right to a refugee in any territory overseas, in effect. This is the claimant's case, as I understand it. In any territory overseas, subject to there being a continuing Article 40 declaration, they can, it is said, demand entry to and residence in metropolitan territory, in other words, into the United Kingdom. That would be, we respectfully submit as a general point, a surprising inroad into immigration controls, and even more so if, in truth, on the facts, it isn't necessary for the purpose of protection under the Refugee Convention. The purpose of Article 26, we submit, is to prevent restrictions on movement and residence. For example, residence in a camp in a particular country. If you're a refugee, you must stay in a particular place.
Article 26, I mean, your argument is basically that it looks at the unit, accepting on any view the SBAs are a unit, whether they're the same unit is a different matter. And that seems, that it's relevant to look at the provision about aliens, isn't it? Because there's nothing which, unless one looks at the particular unit, there's nothing which deals with what must surely be recognised as a possibility, namely that it may not be open to indigenous people to move from one unit to another.
Yes.
I mean, I presume that's the case, that the Cypriot population of the SBA is, well, we know it is.
They don't have a right to come to the United Kingdom.
They don't have the right to come here.
Yeah. My Lord, my submission is, you're right. Yes is therefore the answer.
I mean, I suppose just taking France, they have overseas territories which are part of France. It maybe the position is different there if you structure your constitutional arrangement such that Réunion is actually part of France.
Department, isn't it?
Yes, maybe they can just move from one inhabitant of Réunion, but that's
So
certainly not the case with the
If you
British.
compare them with aliens in that situation, you'd end up with a different legal result because there are no barriers to movement as between the territory and
Yes.
metropolitan territory.
Yes.
My Lord, you know that there are, and it's common ground, I think, that there are
barriers,
immigration
yeah,
controls and restrictions. So my Lord is right, and the submission, if we need it, can be made in either or both of these ways. Firstly, territory, the prime case is that territory, properly so construed, means, applied in context to the SBAs, it means the SBAs, or indeed any other British overseas territory or equivalent. It must be a general argument that applies to all of those. That's why I say the logic of my learned friend's case, if not his actual case, is that if this works for the SBAs, then why doesn't it work for Fiji, the Falkland Islands, Gambia, or the Gilbert and Ellice Islands? Now, of course, the Republic of Kiribati.
Well, the logic of the proposition is that the refugee could move anywhere in any British Indian overseas territory.
Yes, and vice versa. So why not from the UK out? But our argument of principle that it means the unit, if I can call it the unit rather than to distinguish it from the metropolitan territory, is, at least to some extent, it draws on the earlier argument, the recognition that overseas entities are distinct entities in their own right, and they're made on the basis of discussions with and the agreement of the overseas territory to bind itself to this substantive provision. And the logic, therefore, is that territory must be referring to those. It takes into account, therefore, all the practical, legal, social, etc., difficulties that, or distinctions between the metropolitan territory and the unit. I mean, I said vice versa to my Lord, but the logic of their case is surprising. It's great odds with that distinctness of separation which appears to underpin the convention and the signing up of overseas territories. But why couldn't, on the logic of their case, anyone arriving in the UK decide to reside in any of the overseas territories without having even been recognised by those overseas territories? Why couldn't they have gone to, or go to Mauritius or wherever else it may be? And even against the wishes of that overseas territory. Suppose they said, well, I'm sorry, we haven't got room for them. Nothing we can do, we can't cater for them, we simply can't deal with them. Is the right answer then that you have to denounce? We respectfully submit that that's far too extreme. But the UK, on their logic, I mean, could they compel the overseas territory to take them if you flip it round and ask them in reverse? And our short submission is, well, plainly not. And territory, of course, takes its meaning from the context. True it is that in some of the articles, I think at least in one, there is a specific splitting out or distinction that is drawn in 19.2 in relation to the liberal professions, in relation to dealing separately, as it were, with a unit and the metropolitan territory. But whatever the precise intent and purpose of Article 19.1 and 2 read together, it's evident why they split it out on that basis in that article. But the fact that they've done so there doesn't mean that you then read territory across the other substantive provisions in the Convention so that it applies to metropolitan and all overseas territories as a compendious term. That simply doesn't work. I mean, it doesn't work if one takes as an argument, take that as the argument. If you go back to Article, I don't know, take any of the articles, Article 17, by way of example, which is about wage earning employment and how long you have to stay in the country and so on. Let's give you a moment to cast your eye down Article 17 on page 901 to see the flavour of it.
Exactly.
So the obligation is to accord to refugees lawfully staying in their territory, so it's the same word that's used, the most favourable treatment accorded to nationals of a foreign country in the same circumstances as regards the right and so on, in any case restrictive measures and so on and so forth. But you could have, and just take this as the first point as to why it doesn't work, my friends' reliance on territory meaning everything, all the territory, metropolitan and overseas. One could have, do you remember there was a reservation, one of the reservations that was made when the thing was originally notified in 1956, I think altered the 3 years in this article to 4. Now, true it is, I think, if I've understood it correctly, but true it is, I think, that the 4 years was a reservation both in relation to the UK and in relation to those who were signed up in 1956. So on the facts, it doesn't make a difference, but one can posit a situation in which an overseas territory signs up with its own particular reservation applying only to it, and suppose it said 4 years. How then would it work? Who's the comparator? How does the comparator system work in that context if there are reservations imposing different conditions applicable to the unit as compared to the metropolitan? But on any view and in any event, focusing on Article 17, to know under Article 17 to what extent a refugee is allowed to work in his first 3 years, you have to look at what is the most favourable treatment accorded in the territory, whatever that means, to nationals of a foreign state. On our interpretation, that's tolerably easy, because in metropolitan UK, you've got nationals of the 27 foreign states of the EU, and they've got an unrestricted right to work and so on. And that's the most favourable treatment. So refugees in the UK's metropolitan territory get that too. But imagine a territory where no aliens are allowed to work without a permit. I think Isle of Man might be an example of that. A refugee with less than 3 years residence wouldn't be allowed to work either. Easy to understand, fair, and reflects the quasi-autonomy of the overseas territory. But on the claimant's construction, that's hard to make sense of. Does the Isle of Man have to afford immediate rights to work to all refugees without calling for the licence which is otherwise required from aliens in that territory, just because the UK metropolitan territory has a different set of rules? And as a textual indicator, looking at 17, you see the reference in 2A to 3 years residence in the country, which it might be thought is something of at least of an indicator. You could hardly say that all UK sovereign territory anywhere counts collectively as a country when one is positing these questions in the context of the UK and its overseas territories. So Article 17, but one can take the example from pretty much any of them. Article 18, self-employment, that gives you the same run of points. Articles 21, housing, same points. 23, again, same. 24, likewise. If there are differences, distinctions between the state of local law, the conditions as they apply to aliens, the thing becomes very, very difficult indeed to operate. So that's the first argument we put. Territory construed in context plainly means unit and not everything. And I suppose there's an alternative, or in any event, are you within the rider, subject to the regulations applicable to aliens generally in the same circumstances? So the comparator is aliens in the SBAs. Their being in the SBAs is, one might have thought, as close as possible to the same circumstances. They don't have a right to pick residence. So there's no right to pick residence for locally resident aliens as between the UK and, for example, the overseas territories. Indeed, it might be thought it would place them in a better position even than even than British citizens who have no right just as a result of that fact. So we respectfully submit that there is no right to reside under this article in the United Kingdom just because you happen to be a refugee in the SPAs. And at this level, and this argument has to work on the basis of mere presence in one part of the overall sovereign UK territory. I'll return to what happens if you can't reside within the SPAs, but on Article 26, we respectfully submit there's no right of the kind indicated. And the same point, I've taken a little bit of time in relation to territory, because it again, in Article 32, and that obviously if you haven't got a direct right under 26, which refers in terms to freedom of movement and residence, it might be thought to be quite surprising that you could drag it in through some of the other less directly applicable, or less obviously applicable articles. But if one takes 32, territory again means we respectfully submit the SBAs. But you'll bear in mind in relation to Article 32 that the judge did consider at first instance in some detail on the evidence whether the position was in fact that these refugees were subject to constructive expulsion, effectively. He did so specifically and particularly at paragraphs 341 to 342 of his judgment, and he rejected the claimant's case that that was the position.
Mr. Eady, I think it's being said that it's only very recently that the Secretary of State has said to the claimants, well, of course, you could stay here. If it's right that that is a new dimension to your case, if it's right that the case has always been, you should go to live in Cyprus and make the claims that we have negotiated that you should make, then bearing in mind carrots, but also sticks, mightn't it be a case for constructive expulsion?
My Lord, we respectfully submit not, for the reasons that the learned judge gave, which is that it isn't, I respectfully submit, constructive expulsion if you do have, particularly in the context of the SBAs and the close links with Cyprus and the independent republic, if you do have, and it's a question of fact whether you have it, but if you do have a durable solution, to use that phrase, whether they are living in the SBAs or whether they're living in the colony of Cyprus, whether they're invited to resettle, we respectfully submit that isn't properly to be regarded as constructive or actual expulsion. There's never been any question of saying to them, you have to go. And so the only case can be one of constructive expulsion. It's too hideous to stay, so we have to go. They've never put it on the basis that we've insisted that they go. We never have.
Well, they haven't gone, so...
They haven't gone. They haven't gone. That doesn't necessarily shut out a case of constructive expulsion, but...
Well, it shuts out a case to the effect that it's already happened.
Yes, it does.
What does it mean? I mean, what is the next step in the argument on constructive expulsion, which leads to a conclusion that they have the right to come to the UK? Do you need to deal with that?
My Lord...
Our paragraph 3 seems to deal with the situation where there is a constructive expulsion. Contracting states allow such a refugee a reasonable period within which to seek legal admission into another country.
Yeah.
So,
but my Lord, that is
I suppose they would say that they're seeking admission here, are they?
they're seeking admission here, but there's a non sequitur, which is, as a result of 3, which is that if they, even assuming there is expulsion or constructive expulsion, the question is whether that leads to a right to come here, or whether in truth what then happens is that there is a reasonable period. I mean, this is actually conferring a right on them to, before they go to seek.
You say you've repented, or if the policy is no longer whatever it was that is complained about is the primary case.
Exactly so, exactly so. But on the construction of Article 32, the question is whether they whether they can say, well, we were going to be expelled or we have been constructively expelled, and the consequence of that under this article is that we thereby have a right to move to and to reside in the United Kingdom. And we respectfully submit that can't possibly be spelled out from that article, because we say the territory that is referred to there is the SBAs. They haven't been expelled from there. But even if there was constructive dismissal or constructive expulsion, it wouldn't follow that they had to come to the United Kingdom if there was another alternative. I mean, after all, if they have a right to be allowed a reasonable period to seek legal admission into another country, if the position truly is that another country is prepared to take them and there is a durable solution, why wouldn't that be sufficient for this purpose? Not exactly the point that is being made in 32.3, but it's close to it. But in any event, on the evidence, the position before this court is, court at first instance looked at the expulsion question on the facts and concluded no expulsion and rejected the case on that basis, and the Court of Appeal agreed. See paragraph 83 of the Court of Appeal judgment. And we respectfully submit no obligation there, or no, this court shouldn't interfere with those essentially factual findings. Would you give me one second? Yes. Reminded my learned friend, I'm grateful who appeared at both levels below, but it's wrong to say that that so far as at least the currency of these proceedings has been concerned, that they've ever been told they have to leave. I think in 2010 there might have been a question of that, but throughout these proceedings, they've always been, the position has always been that they've been allowed to stay. I think that's right. So that's Article 32. Article 34.
Allowed to stay where?
In the SBAs.
Allowed to stay where in the SBAs?
Well, I think not specified.
No. Very well. Thank you.
But you're aware that the alternatives that are presented as a durable solution is either stay in the SBAs or resettle in.
Thank you.
Yes, I'm given a reference for that point. The claimants said, the respondent said in evidence before the trial judge in the skeleton argument. It's a reference to the skeleton argument at first instance, which is tab 14 of core volume 2. The relevant page is 672, and the relevant paragraph is 53.
Thank you.
And I hope that answers my Lord's question. But yes. I think I gave you the accurate answer, which is not specified, but they can. Article 34, then, naturalisation. That is a duty, as one sees on page 909, which is cast in pretty careful terms.
Article which one, sorry?
Article 34.
Yes.
This is the other one that, I mean, all of these articles are being relied upon as the source of a right to move to the UK and then reside here in the metropolitan territory. That's why we're going to all of these. That's the question I'm addressing. And this duty is cast in very careful terms, very broad terms, allowing, one might have thought, very significant flex for states. It's for them to judge and weigh whether it is possible to, for example, assimilate refugees. The same, but the same point applies. This must be assimilation, such assimilation as is possible in the SBAs. They have that in the only way deliverable, which is assimilation into the now 10,000 odd Cypriots resident in the SBAs, living for all practical purposes as part of the ROC. But more broadly, one can't convert this right, even if it applies, into a right to move to and reside in the United Kingdom. It must encompass and include the right of a state in the context of overseas territories to maintain immigration controls so as to preclude a position where there is an unrestricted right to move and reside in all parts of the territory, in a broad sense, at the choice of the refugee. So those are the specific articles that are relied upon as conferring this right. And bear in mind, it's a very specific right that is being asserted, which is to move to and to reside in the United Kingdom. The question that troubled the learned judge, and one can understand it entirely in human terms, but the question that troubled the judge is what happens if the refugee convention, as he put it, cannot be complied with in the SBAs. The first point, perhaps, to make in answer to that question is that there is an analytical step which doesn't appear to have been subject to much consideration in the courts below, but is necessary, I submit, to this issue and to some of the factual analysis that follows. It is how living conditions tie into the Refugee Convention. And of course, none of the rights that we've just been referring to are really about living conditions. Perhaps the closest to it is assimilation, but that's about assimilation and naturalization, the concepts sitting side by side, and it's so far as possible, and it's not about living conditions, at least on its face. The learned judge added a rider to Article 26 that said that's subject to the ability to deliver compliance with the Refugee Convention, slightly question-begging. If they can't do that, then Article 26 might impose a freedom to move and to reside in metropolitan UK, but not explained on what basis that implication into Article 26 actually operated. And on its face, it's actually about movement and residence. It isn't about living conditions. And of course, the point is an important one because that is an analytical step or jump that has to be made in order to make the argument work. Now, I say at once, living conditions and basic standards no doubt are part of the ECHR.
Well, are also the subject of specific guarantees in the Refugee Convention.
But those aren't, as far as I'm aware, those haven't been relied upon.
No, I mean, for example, Article 21 is housing, 22 is education, and so on. Social Security is 24, and there are various others. This whole chapter, chapter 4, is concerned with welfare.
Yes, and those are to equivalent treatment, but again, those are to equivalent treatment to the treatment of aliens, as it were. But as I say, what appears to have troubled the learned judges, well, these are potentially awful conditions in which they're being made to live, in effect, and so one can derive a right to move from those. But none of these articles, which we respectfully submit are closer to living conditions, but none of these articles create such a right. And before one concludes that the implied right to be able to move to the metropolitan territory can be implied or inferred from them, one does have to consider other options, other possibilities, including other legal possibilities. And we know, and this is clear, we know that the ECHR has now been extended to the SBAs, and we know that they do in fact have a local ordinance providing for that. So to the extent that a claim can be made based on housing or living conditions or falling below the basic level of subsistence, and that raising issues under Article 8 or Article 3, which is the common way in which it's been litigated in this jurisdiction, there is a route for dealing with that. One can't assume that that route isn't going to be operated.
My lady, my lords, I hate to interrupt my learned friend, but just out of fairness to him and to assist him, may I please just direct attention to 3 paragraphs in our printed case. Firstly, on the point he was just on, paragraph 140 at MS 226, and then on the point that he was on previously, about Article 26, are paragraphs 133 to 134 at MS 224. Thank you. I'm sorry to interrupt.
Lady, my lords, if I want to come back on those particular paragraphs, may I reserve the right to do so briefly in reply, rather than interrupting the flow of it. My submission is that one needs to be very clear about, as I say, about the punchline which the claimants ascribe to these points. However put, they are seeking the right to enter and reside in the UK on the back of conditions that are said to be a breach of the Refugee Convention. And we respectfully submit in point of principle that that is a non sequitur. It's a non sequitur because that consequence, the creation or existence of such a right, does not flow from living conditions, however dressed up. It does not do so inter alia because there are other ways in which concerns of that kind can be dealt with without affording any such right. And you can't, I add, self-create a right of that kind by declining to take steps open to you to deal with those issues. And there are two routes for dealing with those issues that are available. Firstly, access the benefits that are available from the Republic of Cyprus and live either in the SBA or in the ROC. And the Secretary of State's position is that either or both of those represents a durable solution. Come back to that. But also, and I take this first and briefly, to make, if it would be appropriate to do so, human rights claims in the SBAs.
That's one again.
Access the benefits available from the ROC and live either in the SBA or in the ROC. But the second one is, assume you stay in the SBAs and you've got concern about living, whether it's housing or anything else, subsistence and not being paid benefits, and if that raises issues of that kind, you can make human rights claims in the SBAs. There is a local law equivalent to the Human Rights Act. I've given you the reference already, CV3, Core Volume 3, Tab 38, 1117. And so Article 3 and Article 8, not A1P1, but Article 3 and Article 8 are in play. There is plenty of case law domestically about not allowing the conditions in which refugees live in this country. There is plenty of case law dealing with those articles as they apply in that sort of situation. And it can't be suggested that any implicit obligation in the Refugee Convention in relation to living conditions or linked to it affords greater rights than under the ECHR. But the key point is that ECHR protection exists within the SBA systems, and indeed challenges have been made to the living conditions there. Just before going to that, I said that's the place and that's the mechanism for accessing courts and making these sorts of complaints. It's at least the spirit of the Berkeley case that came to this court on jurisdiction and justiciability, so didn't have to deal with ex parte launder. But you'll recall there that there was an HRA in the Channel Islands, and the argument was, well, even if there is jurisdiction to consider the matter over here, better to raise the complaints over there because they've got their own local legislation allowing you to do that. Slightly different because that was dealing with challenges to legislative setup, but at least the spirit is similar. And one has an example. If you go to Authorities Bundle 4, you go to tab 45, you will find a judgment of April of this year in the SBA, in the SBA courts, page 4344, I'm sorry, my lord. It's a case called Hesu, who I think is a near neighbour of these claimants, living in Richmond Village as well, and you see the nature of the complaint. And again, I just use this as an example, but you see the introduction and agreed facts on 4345. The plaintiff, so the state there, was trying to get an order that, requiring them to give up possession of the premises in Richmond Villages and vacate. And the question was whether that order should be made by the court. So the direct issue under the HRA was whether or not it was appropriate to make a possession order, in effect. That's been the subject of litigation up to this court as well, as you know recently, whether it was proportionate to make a possession order in the circumstances. But that's the nature of the challenge. You see they arrived at exactly the same time as our claimants, para 3. there's extensive reference to the judgment of Mr. Justice Foskett and his helpful exposition of the facts and the changes and the law and everything else. You see that referred to for the first time at paragraph 5, and it's then called the Tag Eldin case rather than the Bashir case. But the evidence that is summarised at 6, you see the nature of the complaint. So a notice of vacation was placed. I think there wasn't much dispute, but that there were serious problems with the property in which they were currently situated and which they wished not to be moved away from forcibly or made to evict, as one sees from paragraph 10. You'll have seen reference to asbestosis or asbestos in the learned judge's judgment in our case, but so similar sort of issues arising here. The legal issues, look at paragraph 26 on 4349, if you would. It's the Pinnock case. Complaint being made under Article 8, one sees from 27, and indeed also Article 3, sees from para 30. There was a suggestion that the plaintiff was not acting as a public authority, which received short shrift. One sees from the tail end of paragraph 40. The analysis of Article 3 starts at 71. No sustainable argument under Article 3, but then he turns to Article 8, and he analyses the Pinnock case, which will be well known at 88. And in essence, what the dispute came down to was whether or not the alternative accommodation that was on offer from the SBA authorities was good enough. Was it sufficient to persuade the court that it would be proportionate to make an eviction order, making them give up possession of the slightly dangerous-looking property they were currently living in? And the answer that the court gave to that question was no. It wasn't suitable for all of the reasons that are given, including in particular in paragraph 90, 92, 94.
Can I ask Mr. Reedy, in paragraph 140 of the respondent's case, which Mr. Hussain just drew our attention to, it said that it's common ground that the UK cannot fulfil its obligations under the Refugee Convention within the SBAs. Is that in fact common ground as far as you're concerned? Well, if it's not common ground, this court can hardly resolve that question of fact, can it?
Well, my lord, that is the issue to which I'm going to come on the procedural issues. But my lord is right. I'm sorry. I should have dealt with that at the outset. But it isn't common ground, and it isn't common ground because I've taken you through the way in which we say the Refugee Convention works and the rights that are actually accorded to it. And if it's cast in terms of local conditions, I'm making the submissions that I am now. So there are two routes. One of them, as I say, involves going through the ECHR door, if that's the concern that truly arises, and the Hessu case stands as a good example of a precise use of the SBA courts for that very purpose. Yeah, I put it away. My learned friend draws your attention, if you still have it open, to the last two paragraphs.
We've been reading those.
I'm grateful. Can I turn to the second of the routes, which is living in the SBAs or the ROC with the status of ROC refugee? And the learned judge's reasoning in relation to that, if one has it to hand, if you have it to hand, is at paras 343 to 345 of the judge's. Sorry, I've got the wrong file. Of the judge's judgment. And 345 in particular. Page 456 in core volume 2. So that's the reasoning of the learned judge on this issue. But the operative decision is the now retaken decision, post the Court of Appeal judgment of the 6th of July 2017, which I mentioned. You find that decision at 2D, volume 2D, appendix 2D, tab 228, page 2905. This is the operative current decision of the Secretary of State. And can I apologise and ask you just to note that in our case at paragraph 59, there is a wrong reference. It says appendix 2A. It should be a reference to 2D. 2D 228 2905. And again, you've probably read it already, but if you haven't, can I just invite you to cast an eye in particular over the passages from immigration rules on 2906 through to the end of the letter. As I say, if you've read it already, apologies, but I think it is worth your at least reading that letter now if you haven't had a chance.
Mr. Eady, of course, we've read that, and we've read the repeated assertion that you can, in the Republic, obtain welfare, healthcare, education, employment. And then, of course, having read Mr. Hussein's case, we read the last appendix, the letter from the UNHCR dated 26 October, which says it isn't nearly as simple as that.
Yeah.
In particular, welfare assistance depends on residence in the Republic, which, of course, they haven't been clocking up. And healthcare depends on welfare. And labour market depends upon having a proper status, which they don't, and so forth and so on. And so my question to you is, where is the letter to you from the Cypriot authorities saying, there are these problems, of course, on paper, but in the circumstances, we will guarantee that there will be no problem about access to provision A, provision B, provision C, provision D. Because all seems to be silent from the Cypriot end.
Well, my lord, not quite silent from the Cypriot end. I mean, to some extent, it drifts into what our response is going to be and would be when fully done to the UNHCR letter. And that is at the nub of the procedural problem that I raised earlier. But can I just take it briefly in stages? I'm not sure it directly answers my lord's question, because that will require the detail of the response to the points that my lord has put to me raised properly, entirely fairly by the UNHCR. But if you go to our, I don't know where you put our response submissions, the appellant's submissions in reply. Maybe that they are loose. I hope I did quadruple check that you've received them, but
they're loose in my pile.
are they loose? I'm grateful. But you'll see at paragraph 20 that there are various documents providing that the individuals concerned are entitled to all the rights given to recognised refugees by the Cyprus refugee laws. So a state of refugee treatment equivalence, if you will. That's the quotation in paragraph 20. And you see exhibited at Annex 2 to those submissions, page 34, if the numbering is the same as mine, the sort of letter that has been received. There, in the case of one of the individuals, is recognised to being entitled to all the rights given to recognised refugees by the Cyprus refugee laws of 2000 to 2005. So that's the written statement from the Cypriot authorities of an equivalence of treatment. And then one goes on to come more directly to the question my lord has put to me. Specific checking was done by the SBA authorities of the Cypriot authorities to ensure that that position, as it were, inured, given the length of time that has passed. And if you go to the reference given in paragraph 21 of that document, if you take up 2D and go to tab 223, page 2827, 2827. Again, as ever, emails having to be read in reverse order, I'm afraid. 2833, if you start there. This is the letter from the SBA authorities, the email from the SBA authorities, now of June 2016, to the Cypriot authorities, to the Republic of Cyprus authorities. And you see on 2833 what is done. I attach a letter issued by your department in 2007. That's the letter we've just seen. That's the form of letter we've just seen. The letter explains the entitlements for this particular family. Could you reaffirm that the arrangements in the example letter attached still remain and are extant? I'm reviewing letters in the light of the legal challenge. Grateful if you or the appropriate could confirm that the letters are still valid, still apply to all the refugees. And then 2831 is the initial response. Confirm that in relation to the document attached, still enjoys the entitlements provided by the Cypriot government. Bottom of the page, 2831. Propose that we have the list of all the people concerned so we can check the cases one by one and confirm. Do you see that at the bottom of 2831, the email of the 23rd of June of 1323? And then the answer that comes back, the list is provided, and the answer that comes back is 2827 from the Cypriot authorities. After checking the details you provided on our system, I can confirm that all the persons concerned, including children, still enjoy the entitlements provided by the Republic of Cyprus. So that is where one has got to as it were, formally so far. So they have been recognised as refugees by the Republic of Cyprus. They've been recognised as being entitled to equivalent benefits and entitlements to those who are refugees in Cyprus proper. That has been confirmed more recently, and I think there's even a more recent confirmation still, but that doesn't matter, that they are entitled to those matters. So they can live in the SBAs and access the benefits, or they can resettle and reside if they wish. And in the meantime, if they want to stay in the SBAs, of course, they can challenge under the relevant provisions of the Human Rights Ordinance. And so just before coming to the practical problems that are created by the issues that are created by the recent letter from the UNHCR, there are, we understand, some points of principle that are raised in relation to that state of affairs by the claimants. And the first is that it isn't open to the United Kingdom, it is said, to rely on solutions requiring relocation against their will. Our answer to that is that they can live in the SBAs. That's one of the two options available. It's open to them there to access the benefits that the Republic can provide and is willing to provide, or they can relocate. They don't have to relocate, but the option is a proper and durable one, and they can't, as I put it earlier, self-create a right to come and reside in the UK from their unwillingness, for whatever reason, to access the benefits that are available for them. The second point that was made in principle, if I've understood it correctly, is that the MOU, which you'll have seen reference to, is not, as they put it, fit for purpose. It is maybe worth just briefly going to the MOU, because that is the subject of some submissions by them. It's in core volume 3, tab 35, page 1085, and you'll recall this is the 2003 MOU, and there was all the debate in front of Mr. Justice Fosk about whether it applied and whether they'd gone lukewarm, cold, different to it. But in 2005, on our case at least, they committed themselves to it, so far as these refugees are concerned, and we've now seen, perhaps most relevantly, that maybe it undercuts the entire need to go to this, but we've seen their confirmation in 2007 and again in 2016 most recently, that they say the MOU is not fit for purpose. In truth, we submit, it is plain from the recent exchange of emails that they're treating them as refugees with the right to benefits, and that's perhaps more important than historic debate about the agreement. And we note that the Refugee Convention is something to which the ROC is now unequivocally and in its own right signed up. It's promised to treat them as refugees who arrived in the SBAs and recognised as such there. And the points I think that are made are firstly that the clause 12, and it's a point that was made by the UNHCR as well, but clause 12, it is said, indicates, as it's put, the temporary nature of the MOU, which our answer is that clause 12 doesn't do anything of the kind, and one only has to read it to see that. This is a commitment undertaken by the United Kingdom not later than 1 year after the decision granting the relevant status has been taken to endeavour to resettle them. But it doesn't mean that the thing ends or that in some way undermines or is to be taken generally as undermining the applicability of the guarantees to these individuals. And indeed, so to construe it would be wrong, but even if it were right, it's been entirely superseded by the confirmation that they will be treated as refugees by the Republic of Cyprus. Then they say, correctly, that the MOU is terminable on 3 months' notice. See clause 18. So it is. But so what? So far as they are concerned, it isn't executory, it's executed. And their status is assured. It's only those arriving after the termination of the agreement, were it to be terminated in accordance with that provision, who would be affected by that termination. So we respectfully submit that neither of the points of principle are good ones, and so all that that really leaves, we respectfully submit, is to come back full circle to my Lord Wilson's point to me, the position in relation to the UNHCR. Are these things, however expressed, and although they may say equivalents of entitlement, are they in fact ring round with difficulties? I mean, one may have a temporary and tiny loss of confidence for all the respect one has for the UNHCR if they're taking the clause 12 point, but leave that on one side. They have raised issues of the kind that my Lord put to me in that letter, and we, of course, respect and take seriously that sort of intervention by the UN.
But they're not new issues, really, are they, Mr. Eady?
They're not terribly new issues, but there is a debate yet to be had in relation to those. I mean, our short position is that, it's going to be, I suspect, that they can access all of these things. They've just chosen not to. And that all of these things are available. There is equivalence of treatment for these people as compared to refugees who are in the Republic of Cyprus. The Republic of Cyprus is a signatory to the Refugee Convention. To the extent that it confers rights, they are entitled to those rights in Cyprus or from Cyprus. But to the extent that there are thought to be specific factual issues raised by that letter, the one thing we respectfully submit that this court cannot do and should not do is to proceed on the basis that the UNHCR letter is capable of demonstrating that that equivalence is not in fact equivalence, that there are unholy barriers in the way of these individuals accessing the rights in question. And it is very difficult indeed, we respectfully submit, to see how the court, this court, could properly resolve that set of disputes. Now, that raises a slightly broader procedural question for the court to consider, which is, well, what's the right way of dealing with this whole area, as it were? And we respectfully submit that it is entirely proper and possible for this court to opine on the nature of the rights that the Refugee Convention confers and the obligations which it imposes on states. We're on the assumption that it applies in the SBAs for this purpose. And that in particular, it would be useful for this court to opine to save you having to do it in 2 or 3 years' time. It would be useful for this court to opine on whether or not implicit in any of the rights that are really relied on by my learned friend, there is a right to move to and reside in the metropolitan territory. We submit that that's entirely possible for the court to rule on, and the court, we respectfully submit, can rule upon whether or not it is the points of principle I identify, whether or not it's open to us to rely on solutions requiring relocation, if that's really what's happening. We say it's not, and whether the MOU is fit for purpose in the manner indicated or asserted by the other side. But whether you can resolve an essentially factual dispute as to whether or not in truth the benefits are accessible in the way that we have asserted is a different matter. And we have suggested, I hope taking a realistic and fair view, that that issue at least isn't appropriate for resolution, either by this court because it's a court of principle, or by this court because the issue is not yet ready for determination. It would be thoroughly inappropriate and unfair, we respectfully submit, for the court to seek to opine on issues of fact that may exist between a body whose views we have to take seriously and respect and do, namely the UNHCR, when we haven't even had an opportunity to produce a full and final and proper response to the concerns that they have raised. And the appropriate course, therefore, at that stage, and in relation to that narrow set of issues, would be to remit it back to the administrative court for resolution. None of us relish or want yet further litigation in this matter. But if that course is followed, the thoroughgoing benefit that this court's judgment will have provided will have been to fine and narrow those issues down to that point. and we respectfully submit, therefore, that that is the appropriate procedural course for the court to take. My lady, my lords, those are the submissions. My learned friend, Mr. Hussain, will have, I'm afraid, on my watch, 10 or 12 minutes rather than the 15 that I conditionally promised him.
Oh, did you? Oh, that's unknown to us.
Well, it was on the, I think it was on the face of the, it was on the face of the hymn sheet for the hearing, in italics over the page, or maybe that.
Yes.
It was agreed that if I finished a little
Should
early,
you finish earlier? Yes,
yes,
indeed.
it was
Yes.
decent enough to allow me to finish late, but
Yes.
given the hurry up that I got from my lady, I hurried up.
Thank you very much indeed, Mr. Reedy. And that's on the assumption that Mr. Rowe does not wish to follow you. It appears to be a bounded assumption. Mr. Hussain. I think you have about 12 minutes, Mr. Hussain.
My lady, my lords, in 1994, a few years before the respondents made their landfall in the SBAs in Cyprus, Lord Justice Steyn, as he was then, said this: "The lot of refugees is often a desperate one. The spectre of torture or death or both often haunt them. The Amnesty International reports graphically document the scale of inhumanity of man to man. That is why it is right to treat the rights of asylum seekers as fundamental rights. In a European democracy founded on values of liberty and humanity such as ours, our law accords special protection to such fundamental rights." That was the Abdi and Gawe case in the Court of Appeal. It later came to the House of Lords. My lady, my lords, in his report in March 2016, the Council of Europe Human Rights Commissioner, following a visit to Cyprus in late 2015, said this: having referred to the dire situation of the respondents, he expressed his serious concern about the long-standing plight and precarious situation of those, including the respondents, and continued, "The UK retains its sovereignty over the SBAs, thus being responsible for the respondents. The Commissioner urges the authorities to meet their legal obligations, thus ending their protracted and psychological suffering by resettling them, even belatedly, to the UK. There is no reason to believe the resettling of this small group of persons to the UK after all these years would create a pull factor." And the reference for that is Authorities 6, tab 57, page 4777, 4777, paragraph 51. As you've seen, my lords, my lady, the UNHCR, as recently as a couple of months ago, also made it clear that given the protracted failure, it's not a one-off, it's not new, as my lord said, the protracted failure by the Republic to deliver practical and effective protection of the respondents' refugee rights in the Republic, resettlement in the UK is the only proper, durable solution. It has been saying this, the UNHCR has been saying this for the last 4 years, since September 2013. It said it again in June of this year and again a couple of months ago. My lord, my ladies, be aware that these proceedings commenced because after years of attempting a political solution, the respondents, as a last resort, sought to move the UK courts to seek to compel the Secretary of State to meet the UK's legal obligations under the Refugee Convention. I'll then now move, if I may, with that brief introduction to the three issues that my learned friend addressed you, although it's fair to say he didn't really separately address you on the third one at all. This is the spirit question. On the first issue, does the Refugee Convention apply? We say there are three routes to the answer that it does so. This is our case at paragraphs 10 to 127, pages 178 to 219. All my references will be to the electronic bundle. The Secretary of State addresses this at paragraphs 1 to 33 of her case. My learned friend Mr. Fordham addresses it at 18 to 26 of his case, pages 311 to 313. The three routes are, firstly, the SBAs were not a new political entity in the sense that Lord Hoffman should be understood to use that term. They were not a new constitutional unit or overseas territory as a matter of domestic law. Second, even if one looks beyond domestic legal classification, there is sufficient continuity in the administrative arrangements to say that they were the same political entity as the colony of Cyprus. But third, we say with great respect to the House of Lords in Bonku, in that case, it was wrong to decide, in respect of an identically worded territorial application clause, that in order for territorial extension previously made in respect of a territory for whose international relations the UK is responsible, for that previous extension to continue to have effect, there must be a political entity which must remain the same as a matter of domestic law. And the House Lords were, with great respect, wrong, because firstly, Lord Hoffman, in that case, and the Secretary of State here, are wrong to say that territory cannot mean land, because a state cannot have international relations in respect of land. Territory in Article 40 of the Refugee Convention, Article 56 of the ECHR, can mean land, just as it clearly means land in Article 31 of the Refugee Convention, in Article 33 of the Refugee Convention, and just as the Secretary said, accepts that it means land in Article 29 of the Vienna Convention. And this meaning, we respectfully submit, is not displaced by the reference to international relations responsibility in Article 40. Many states, indeed, including the UK, owe international obligations and enjoy rights in respect of uninhabited land masses, for example, as regards search and rescue, salvage, exploitation, fishing rights, building of military bases. And as we'll see, as my Lady Hale observed, the ECHR applies to the South Georgia and South Sandwich Islands, which has no permanent population at all, 12 scientists, I think, in the quark fishing case. Alternatively, we say, even if the term territory means a constitutional unit in Article 40, then the effect of an extension is to extend the treaty, the Refugee Convention, to the underlying land. The second broad reason we say that Bonku was wrong on this point was that its consequence is that a state can shuffle its pack, as we put it in our case, can rearrange domestically its overseas territories and so avoid obligations in international law as a matter of internal law. And that is flatly contrary to well-established public international law. This is not something, with great respect, Lord Hoffman addressed, no doubt because the point was only lightly touched upon, as he put it, albeit by the most eminent of counsel.
Well, if you're envisaging a deliberate attempt to avoid the application of the Refugee Convention, then why wouldn't the state simply resile from its extension to that territory as permitted by the Convention itself?
Well, there are two answers there. The first answer is, in terms of the denunciation under 44.3, you have a cushioning period of a year, and it could be to avoid that. But the proposition isn't premised on a deliberate attempt. You could have an inadvertent disapplication because you've rearranged your domestic overseas territories, and I
thought your submission was directed to the possibility of Mr. Eadie's submission being used as a tool of evasion. That's the only point of my question.
Well, it could be, and the answer there is, well, you avoid the 1 year cushioning. Indeed, he said that it was a problem for him on his case, with great respect to him, that 44.3 gives you a 1 year cushioning. That's the first answer. The second answer is that you could have an inadvertent cessation, if you like, or termination of an extension because you've reorganised. And that is hardly consonant with the broad objects and purpose of the Refugee Convention. The point's very crisply made, if I may say so, by Mr. Fordham in his case. Now, the Secretary of State says that this formed no part of Lord Hoffman's. That, with respect, is a problem for my learned friend, but it formed no part of it, because it's an absolutely bedrock principle of public international law that you can't invoke your internal law to deny the existence of an obligation, and you can't invoke it to deny performance. So it's not good enough for Mr. Eady to say, well, that it only bites at the second stage. It only bites at a stage where you've established that there is an obligation. The principle bites at the anterior stage as well. That's clearest. We'll see it in the materials tomorrow, if we may, from Article 3 of the International Law Commission's articles on state responsibility. It's very clear. It speaks to the anterior stage. That's on the premise that Mr. Eady is right, that you're not dealing with a continuing situation where there is a shedding of an obligation. Assume he's right. Assume you're completely clean slate. You say it's completely wrong that you are. You're not an independent state. The independent state has a clean state. We don't. Assume you do. Well, you cannot use internal law to deny the existence of an international law obligation. We see that from Professor Crawford's commentary, or Judge Crawford as he now is, commentary on the ILC articles in Article 3 and 32. That's a very significant part of our case. The consequences are dramatic, if I may say so. Imagine nuclear non-proliferation. Imagine there's a territorial application clause and we've extended it to the Falkland Islands. We now want to build a submarine base on the South Georgia, South Sandwich. Can we really repackage our overseas territories, separate them, and say, aha, it no longer applies? So there are fairly dramatic consequences of the idea that you can...
I mean, just take an example. Supposing Jerusalem were constituted into a new unit and where some form of joint control or even sovereignty were arranged, surely that would be a new entity which would be free of any conventions or treaties which bound by virtue of its present existence, whatever that may be. I won't go into anything controversial.
Absolutely it would, provided that there was action on the international law plane. We say absolutely actions on the international plane, denunciation, creation of new states.
Well, aren't we looking at the international law plane here? I mean,
not at all.
You're looking at a very strange couple of creatures created by treaty, regulated, I mean, maybe you would say not created, but certainly regulated by treaty and restricted in a way which certainly didn't apply to the previous colony.
But my lord, the Treaty of Establishment didn't create anything. It didn't even create the Republic of Cyprus, because the Republic of Cyprus is created following the treaty in accordance with Montevideo Convention criteria. Government, permanent population, stable territory, capacity to enter, relations. And there's controversy over whether that's declaratory or you also need recognition. But that's Republic of Cyprus.
Well, the Act of Parliament certainly purported to create the Republic, did it not? The Act of Parliament said there shall be a Republic of Cyprus.
It certainly did, and it's an interesting point as to the effect of that. We would say in international law, the effect of that is, with great respect, zero.
But how can that be so if the Act of Parliament took effect at a time when the United Kingdom was still sovereign in the whole island of Cyprus?
Well, that as a matter of domestic law, that puts it beyond doubt. But going back to my Lord Mance's question, in terms of the SBA, the treaty didn't create the SBA, the Act didn't create the SBA, the Order in Council didn't create it. It's very clear.
It said, I mean, the treaty says the territory of the Republic shall comprise the island of Cyprus, with the exception of the two areas which shall remain under the sovereignty of the UK. These areas are in the treaty referred to as the sovereign bases, and then there's a whole lot of
Yes.
agreements about the sovereign bases, as well as about the island of Cyprus.
That's about governance, use, administrative arrangements. It's got nothing to do with creating it. And it's perhaps difficult to see without
Well,
looking
if you
at...
carve an area out of the one that you're disposing of, are you creating it or not?
When domestic law creates a new colony, domestic law says so. An Act of Parliament or an Order of Council says it. It's happened in Bayat. It said it's a separate territory.
Yeah.
Professor Finnis makes the same contrast between Bayat on the one hand and the SBAs on the other in the Halsbury's laws. We cite the British Antarctic Territory. There's another example of the creation of a new colony. That language is conspicuously absent in any of the legislative material that we have. The third reason, if I may just identify it.
Got a third reason, so
Very quickly, we say there are numerous examples which are inconsistent with the decision in Bonku and illustrate the slightly startling consequences for international law, were it to be right. The question is always, is there territory, land, for whose international relations the contracting state is responsible?
Can you have, I mean, land doesn't enter into international relations, it's governments, it's administrations.
Land doesn't enter into international relations. Governments of overseas territories, constitutional units, don't enter into international relations. The contracting state has international relations in respect of land or its overseas territories. The on behalf of analysis is as wrong as one could possibly get with great respect. That's very clear from Oppenheim. It's very clear from this court's, from the House Lords' decision in Quark. If you look at what Lord Bingham and Lord Nichols say, it's very clear that it's the state that's responsible. The state undertakes an obligation to ensure compliance in its overseas territory. It's not the other way around. It's not a mere agent. You can't have a situation where the agent is entering into a relationship which the principal has no power to enter into.
I don't think Mr. Eady says that it's an agency relationship in that sense. When he said the UK government undertakes on behalf of, he wasn't saying that it was then the British overseas territory that was effectively entering into this.
Well, he was sliding a bit between the two. Actually.
Was he?
I'm sorry to take time.
In a very gentle way. No.
I think he would accept your words in respect of and say they're quite similar to on behalf of, but
You say there's
you
a big
distinguish.
difference. You say there's a big difference.
You say there's a big difference, yeah.
Well, you've made a start, Mr. Hussain. We will now adjourn and look forward to hearing from you further at 10:30 tomorrow.